really pleased to have Finín here today. He's going to solve all of our GDPR problems in the course of an hour, help us to understand what it's all about, and generally maybe reassure us. Finín will be taking questions as promised, so get writing those questions. And we do appreciate Finín taking time out, obviously, to come and speak to us. It being quite a professionally busy time for him. So Finín, obviously, as I said, specialises in data protection, therefore advising clients on issues such as data breaches, data subject requests, and the obligations and responsibilities of businesses in relation to data protection and data security. Prior to joining Matheson, Finín has worked for a variety of state bodies, including the Law Reform Commission and the legal section of the National Consumer Agency, and he's also worked as a business interruption loss adjuster in New Zealand. Thanks.
Hello everyone. Thanks a million, Gráinne, for that. Not sure if I'll solve all the GDPR problems or create more, but sure, look, we'll have to chat about it anyway and see how we get on. We had dinner last night with Aileen, and we were kind of going through the issues that trustees might have. So we'll deal with a few of them today. So she wasn't too happy with me after the chat, so hopefully you will be anyway. So look, GDPR, we've all heard of it now. I've been giving talks on it for the last number of years, and a couple of years ago people's eyes would kind of glaze over when you said data protection and said, you know, that doesn't really affect me. And now I was out having a coffee there and everyone's like, geez, I'm sick of hearing the GDPR. So look, I'll just give, the kind of purpose of my talk today is I'm going to kind of give a broad, basic underline of what is data protection and GDPR. So they'll look at it kind of generally, debunk maybe a few myths a lot of people seem to have around it, but also focus in particularly then on trustees and some of the issues that might kind of affect that area, particularly data subject access requests from disgruntled beneficiaries. So we'll have a look at that. So just to start off, what's actually happening? So there's a 1995 directive that is going to be repealed, and in is coming the GDPR, General Data Protection Regulation. So when is that happening? 25th of May 2018, I think we all know that now. I've marked it in red just to give you a sense of impending doom. But that's going to come in across the board in the EU. And the idea there is to harmonise the law so that it'll be the same across each member state. Now, saying that, it does have derogations within the regulation, which means each member state in particular topics can introduce kind of specific things for their country. So one particular example is the age of consent for processing data relating to a child. In Ireland, that has been set at 13, but it is scoped there to set it from anywhere between 13 and 16 across the EU. So not ideal that will be differences across each EU member state, but I suppose good that Ireland has taken the progressive approach of putting it lower at the age of 13. So the reason I mention the derogations is there will be a new Irish Act coming in this year, the Irish Data Protection Act. So there's a bill, you see there, 2017, which was published in February of this year, and that gives a bit of insight of what the legislation is going to be. Now, this act was meant to come in tandem with the GDPR. So we're a couple of weeks away from it now. It doesn't look like that's going to happen. So it'll be left in a funny position where the GDPR is going to come in, and we might be a bit of a gap there for a while. But there is certain kind of hints we can get from the bill, which I'll talk about as we go through. But just to be aware that there's a new act coming in the next few weeks or months. So look, I'll just quickly look at the administrative fines. So I'll deal with this slide first. I think you're all kind of aware of it, but it's just to scare you and what the penalties might be if we're not all in compliance with the GDPR. So at the moment, the maximum fine under the 88/2003 Act, so the Irish legislation, is €100,000. There has been nowhere near a fine at that height. I think from what I've seen, some of the maximum fines have been around €4,000 with the Data Protection Commissioner from the courts. And this is going to take a massive jump up now, and so for the higher tier fines, it'll be 4% of your annual wide world turnover, or 20 million euro, whichever is higher. So think about that, where, okay, 4% of your turnover, that's pretty bad. But if you're a small business, you could still be fined up to 20 million euro. So just keep that in mind. I hope you're all nicely scared. So look, I'm just going to quickly go through a few of the main terms with data protection. Just a few of the key phrases so you're aware of what they are. So the first one is personal data. What actually is personal data? It's any information relating to an identified or identifiable natural person. So it's effectively a very, very broad definition. It can be anything really relating to an individual, as long as that individual is identified. So you're talking your name, address, phone number, potentially your email address if your name is in there. Bank account statements would be personal data. From a trustee point of view, then you're thinking, what if I have minutes of a meeting and I talk about beneficiaries in the meeting? That's data relating to an actual individual. So it's very, very wide, the definition. It's just any information relating to a living individual. Sometimes that'll be very easy to spot what's personal data. Sometimes it can be not so easy. But I will give a few broad areas of what does and does not constitute personal data. So the first thing is, and for any estate practitioners here, you'll be glad to hear this, data protection law does not apply to deceased individuals. So as soon as you die, data protection kind of stops for that person. So if you get a data protection request, so I've seen one before where a bank got a request for on behalf of an estate of a deceased individual, and that was a data subject access request. That was a simple letter back saying, this person is deceased, not a living individual, there's no data protection rights applied to that person, for that person, so he can't make a data subject access request because he's deceased. So that's one key one to keep in mind. Another big one is, it doesn't apply to corporations or corporate entities. Personal data, think about that now, it can't be personal data if it's not a living individual. So again, another example is, and we've seen this a lot, ABC Limited will put in a data subject access request, and again, very easy, simple letter back saying, you're a company, you don't have any data subject rights, can't put in a data subject access request. So a lot of people get kind of confused on that distinction there. It can only be made by a living individual, and that all the data subject rights only apply to living individuals. Another key one is anonymous data is not personal data. So if I cannot in any way, it's impossible for me to identify an individual, i.e. that data is anonymous, then don't even worry about the Data Protection Acts. So sometimes it's great to have these key things and you just don't have to worry anything at all about the Data Protection Acts or the GDPR. And the final point that I want to make is electronic and relevant filing systems. So it obviously applies to all data you hold electronically in your computer, but it also, the Data Protection Acts also apply to a relevant filing system. So your hard copy paper, if it's held, let's say in a filing cabinet, the acts apply to that as well. So just to be clear, some people think they're mined data, computers. No, it can still apply to hard copy data. And a relevant filing system, the test there is what's known as the temp test. So if you have an intern working for you and you say go off and find the file of Joe Blogs, and an intern can't go off and find that file, then it's not in a relevant filing system. So funnily enough, if you take all your files, messy them all up and throw them into a room, Data Protection Act stop applying. Just to confirm, I'm not advising that in any way. But feel free to, if even just for psychological reasons, throw all your files in. So those are the key points again. Doesn't apply to deceased individuals. Data Protection Act doesn't apply to corporate entities. Doesn't apply to anonymous data, and it applies to electronic and hard paper copy in a relevant filing system. So those are the key points I wanted to make and the key takeaways there on personal data. Now we understand personal data a bit more. There's three kind of terms that are used within the legislation, which I'm just going to go through. Those are a data controller, a data processor, and a data subject. So just to kind of for an understanding of the talk, I'm just going to explain exactly what they are, just so, and because they're core really to the to data protection. So the first one is a data controller. So I kind of given an image there of just keep it in your mind, kind of security guy holding files back. Basically, a data controller is someone who, and it's two things, they control the purposes and the means of processing the personal data. So when you think about that, a trustee would be a data controller. They're getting certain information about beneficiaries. If it's discretionary trust, they're deciding how am I going to process that personal data. I'm deciding the purpose, and I'm deciding how to process the data. I'm deciding the means. So a trustee would be a data controller under the legislation. Now, so a data processor then, so what would they be? A data processor is someone, it's a separate entity from a data controller, and they process information on behalf of the data controller. So a few examples there would be a payroll service operator or a cloud provider for if you're backing up your systems. You're giving them, so take the payroll operator example and say a few employees. You as an employer or controlling certain employee information, you're giving it to a processor and saying, I'm giving you this information just for the purpose of doing the monthly payroll. So giving you this information, but you can only use it for that one purpose. So you're processing it on my behalf. So that's the distinction between a controller. At all times, a controller will decide the purpose and the means, but a processor will process the information on their behalf. So just to be distinction between those two terms there. So and again, bring back to the context of a trustee. Trustees might have, I'm thinking in a kind of professional organisation, they'd have, you know, a number of, they might have payroll operators, cloud service providers, shredding operations might come into that there. You know, think different entities that work on their behalf, they would be data processors. Potentially as well, kind of advisors and legal advisors might come under data processors. Now that's a grey area, and I'll touch on that a bit more when we look at a recent case involving trust and data protection. So I've done up this little chart to try and make it a little more simple. So we have our data subjects there, which are living individuals, and I put a little rainbow behind them to make them look kind of happy. They send their data to a data controller who controls that data, and then sometimes a data controller might send the data to processors, which are different entities. So if you get any takeaway, just keep that image in your mind. If you're kind of thinking, what the hell is a data processor again, you can have a look back at that. Right, so those are the three terms: data controller, data processor, and data subject. And a bit of understanding now of what personal data is. So data protection, it's very principle based, and the reason for that is you can't possibly legislate for every piece of data or type of process that goes on. So there's very broad principles which I've listed up here, and the good news is if you follow these principles, you're 99% in compliance with the law a lot of the times. So always go back to these base principles, and they are, you know, the first one is transparency. Does the data subject know that I have this information and that I'm processing it? Purpose limitation. Why do I have this information? Why am I processing it? Data minimization. You know, why have I sent a big raft of information to someone when I could only send a single file? Accuracy. Keep that data up to date and accurate. Storage limitation. That's a big topic for a lot of our clients at the moment. Is data retention. They might have files and data going back 10, 20, 30 years. The way the legislation is written is you can only hold on to data, you can only process data for as long as is necessary. So if the Data Protection Commissioner, boom, 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 knocks on your door and says, why are you holding this file? And you say, well, geez, actually, I have no reason to hold that anymore. You're in breach of the legislation. So you have to, it's a big cleaning out operation for a lot of people across the board now in getting rid of old files, and making sure that they're only holding it for as long as necessary. You could always do what Wetherspoons did and just completely delete every piece of information they had, because they didn't want, they're probably tearing their hair out dealing with personal data and data protection, so they just deleted everything. And it was more of a press release stunt, but you know, that's an option as well as throwing files into a room. So keep in mind. And the last one, integrity and confidentiality, that's your basic data protection stuff, or data security stuff. We'll have a quick look at that later as well. But there's one new principle coming in under the GDPR. So those actually are all in the legislation at the moment. There's one new one coming in, that's accountability. That means a data controller, so essentially a trustee, has to be in a position to demonstrate compliance. So it's basically shifting the onus onto the data controller to say, show me you're in compliance. So again, Data Protection Commissioner knocks on the door and says, tell me all about your data processing, what are you doing, how long are you storing it, what information do you have. You have to get your records up and say, look, this is what I'm doing here, I can demonstrate, I can prove to you that I'm in compliance. So that's a major new onus shift onto data controllers and processors to show they're in compliance. So that's a major principle which is kind of underpinning a lot of the new obligations in the GDPR. So just before we look at data subject rights and have a look at a few kind of recent cases in this area, there's one kind of final bit of the jigsaw I wanted to talk about. So in order to process personal data, and when I say process, that means it's very, very wide. That means anything, any sort of using, copying, sharing, transferring, even storing data is considered processing. So anytime you process personal data, you need a legal basis to do so. There are a few legal bases, one of which is consent. Everyone seems to get in their mind a bit muddled with consent, and they start thinking, geez, I need consent now of this person, and I haven't got their consent, and they're very focused on consent. Consent is one of the legal bases, but there are others. Now I'm just going to focus, first of all, on the changes to consent, and then I'll kind of show the other legal bases. So just to clarify there, in order to process data, you need a legal basis, one of which is consent. Consent is changing slightly under the GDPR. So there's a certain level of consent now in the law, and it's going up to a higher level under GDPR. From the 25th of May, if you wish to rely on consent as a legal basis, it needs to be up at this higher level. If it's not, you can't rely on it. What is this higher level? Consent must be freely given and unambiguous, and it must be clearly indicated. So, you've seen the first bullet point there, silence, inactivity, pre-ticked boxes will no longer be sufficient. So, if you're ever scrolling through a website and you see at the bottom and it says, it has a pre-ticked box and says, if you wish to receive marketing, if you don't wish to receive marketing material, untick this box. That won't cut the mustard anymore. It has to be a clear opt-in from a data subject to rely on consent. Then there's a few other things, it has to be, can't be bundled in with other things, it has to be clear and transparent that they're consenting. And then another key one as well, one of the reasons why I steer away if I can from ever relying on consent is the data subject has a right to withdraw consent at any time, and that must be as easy for them to do, easy for them to withdraw consent as to give consent. So there's a couple of changes in the area of consent as a legal basis, but if you don't meet that, don't despair, there are other legal bases, and I've listed them here. The first one is processing is necessary for the performance of a contract. You have to process the data to comply with a legal obligation, to protect the vital interests of a data subject, in the public interest of, so don't worry too much about that one. And the last one then, which a lot of people rely on, is processing of data is necessary for the legitimate interests pursued by the data controller, as long as it doesn't fundamentally breach the rights of the data subject. So that's kind of legitimate interest one's a bit of a catch-all one that a lot of people rely on, but you need to be very clear there what legitimate interest you're relying on. So just to summarise all that again, you need a legal basis to process any data. Consent is one a lot of people rely on. It's slightly changing to a higher standard on the GDPR, so if you look at make sure that you meet that standard, and then if you don't, these are the other areas you can rely on. That's legal base of it is quite technical, I'll appreciate, but I just want you all to be aware. So look, moving on now into the right of access and trustees' duty to provide. So I'm not a trust lawyer, but I've been learning a lot about trust and trustees over the last few months in preparation for this. And I appreciate that sometimes trusts are put in place in order, there's an element of confidentiality, secrecy. One classic example I think is, there's an illegitimate child for the family or something along those lines. Other reasons as well, protecting younger family members. For Aileen's talk earlier, protection of younger generations, preventing kind of family members knowing about entitlements or to distributions, asset protection and disinheriting individuals. So there is different case law in the area, and I think the classic one is Schmidt v. Rosewood. And I look at these in my paper as well, and read Londonderry settlement, and then in Ireland it's Chain Nixon v. Bank of Ireland. And what those cases I think broadly say is the disgruntled beneficiary is entitled to, or is not entitled to. Well, I was having this conversation with Aileen last night, and she was very protective. She was kind of talking about her letter of wishes, and she said these cases protect my letter of wishes, and she's almost clutching onto these things very firmly. And she said, as far as I'm concerned, the case law protects a trustee from having to show a beneficiary their letter of wishes, which, as you appreciate, might contain information which they don't want the beneficiary to see. So she was a bit put out when I said, Grant, you have that case law, but the Data Protection Acts don't really care about case law. It's kind of purpose blind when you put in a data subject access request. It doesn't matter why you're looking for information, you're entitled to a copy of all the personal information that a data controller holds in you. So we'll have a look at that now. So what exactly is the right of access? Just to be very clear, this right has existed in Ireland since 1988, a data subject having a right of access to their copy of their personal data. It's not actually fundamentally changing under the GDPR. There's a couple of slight tweaks which I'll highlight, but this is a right that has existed for a many number of years. Now, saying that, not a lot of people have know about this right. And with GDPR coming in the news, a lot of data breaches making the headlines both here and abroad, such as Equifax, Facebook and Cambridge Analytica recently. People are starting to become aware of personal data, realizing there's value to it, realizing, geez, actually I have certain rights around this. So I worked in litigation for a number of years, and what I started seeing in the last year or 2 years was you get in your injury summons for litigation, in a separate letter then you get in a data subject access request. People are starting to realize that, geez, actually, this is a mechanism I can use to get a lot of information for very cheaply and very quickly. So, just to explain what it is, it's a right for a data subject to ask a data controller, as distinct from a data processor, can ask a data controller for a copy of all the personal data that they hold on that individual. So, they have to be provided with a copy of the personal data. Now, when I say a copy of the personal data, and this is a clear point that a lot of people don't appreciate, a data subject access request is an information request. It's not a document request. So what does that mean? A data subject often comes along and says, sure, look, you hold these documents here on me. Jeez, I got very coarse there all of a sudden. You hold these documents on me, I want a copy of all those documents. But no, there might be a snippet of personal data in a document. So let's think minutes of a meeting here, trustee. And let's take that example. If there's minutes of a trustee meeting, and at the top they mention beneficiary A, B, and C, and then the rest of the minutes has nothing at all to do with those beneficiaries. Beneficiary A comes along, puts in a data subject access request and say, I want a copy of that document, of that minutes of that meeting. You can turn around and say, your name is mentioned in the minutes, here is a copy of your name. That is all the personal data within that document. So just to be clear, you don't have to get the document, they're only entitled to the information constituting their personal data. Information request, not a document request. That's a key point I just want to get across. With They're also kind of sometimes being entitled to a bit more information just on the purposes of, so, you know, it might be who did you send that personal data to, the recipients of the data, how long will it be stored, a few things like that. Generally, in a practical level, we just kind of give them a copy of their personal data, and when responding to a data subject request, there's two ways you can do it: get the document, redact all the non-personal data, and kind of give them to them, or extraction, take out. So technically, if you wrap and wrap the document, just take out a piece of paper and write down all the personal data and just give them that sheet, and that's all they're entitled to. So. So actually that was the slide. Things to remember. So since 88, it's an information request, not a document request. And the final thing is then, you get a data subject access request in, you can, there's certain times you don't have to, so it actually puts on to the next slide here. So you don't have to give them every single piece of data you have on them. You can withhold certain pieces of data. Now, first of all, and very obviously, non-personal data does not have to be given. So it doesn't, if it's non-personal, it doesn't relate to that individual, it falls outside of it. There's an exemption, which is the kind of legal professional privilege exemption. So a bit of vagueness in the wording of the Acts, but it's generally considered that it applies to litigation and legal advice privilege. So if you can exert privilege over a document or over information, you don't have to give it. There's other examples then. One is prevention of crime and fraud. One which a lot of people kind of point to, but it's not very practical in reality, is if someone gives a personal opinion expressed in confidence about another individual. So let's say I call one of my colleagues, a complete waster, but I express that in opinion to my HR manager. You could potentially try and say, well, no, that was an opinion expressed in confidence about another individual. But the Data Protection Commissioner doesn't really like that one at all, and it's very hard to actually exert in reality, despite the way it's worded in the Acts. But just be aware that one is there as well, because I've dealt with a lot of data subject access requests, and you'd be surprised what some people say about other people. So, try and do it over a coffee rather than in an email if you can going forward. So personal. So if it's impossible, you can say there's a disproportionate effort to supply the personal data. Again, very hard to rely on that one. If releasing the medical information would cause a serious risk to that data subject. So again, that's a very kind of specific situation, but if giving them certain information would cause more detriment than good, then they might be able to withhold it. And if you've already given them the personal data, then you don't have to apply it again. So that's the certain exemptions under right to access. Just have a quick look at the changes before I focus on one recent case that deals with trusts and data protection. So as I mentioned, right of access has existed since '88. There is a few slight changes now that's going to be under the GDPR. First one is, once you receive a data subject access request, you have 40 days to respond. That's now being moved down to 1 month. Great. Can be extended to 2 months in certain situations, but I wouldn't rely too heavily on that. At the moment, you can charge someone the mammoth fee of €6.35 to process their data subject access request. That's actually the maximum you can charge them, despite, and I've seen access requests cost companies sometimes in the thousands. Under the GDPR, that's moving from €6 down to completely free of charge. You might think that's a small change, but psychologically, I do think that there will be a big increase in data subject access requests from the 25th of May. It's as simple now as banging an email to someone and saying, please supply me with all the personal data you hold on me. And if you wanted to if you really wanted to, annoy a bank, get 100 or 1,000 people together and everyone send in a data subject access request at the same time. That would really annoy them. But again, not advice that I'm giving. But again, psychologically, I think going to free of charge will we'll see a big increase in data subject requests, so be aware of that. And the last point is, it can, if you make the request electronically, the information must be provided in commonly used electronic form. So that might cause a bit of headaches for some people, but those are the three kind of key changes under GDPR. So this is one recent case, 2017, and it's one of the main cases I could find dealing with trustees and data protection, and it's kind of the classic example of a discretionary trust. So the claimants, Ms. Dawson Damer and her 2 children were beneficiaries under a number of trusts held in the Bahamas. They were upset that certain monies were given to other beneficiaries rather than themselves, and they wanted to know why. So they took legal proceedings in the Bahamas against the trustees. The trustees in the Bahamas had a legal advisor, Taylor Wessing, who's a law firm in the UK. And so what Ms. Dawson Damer did was herself and her 2 children put in a data subject access request to Taylor Wessing and said, please provide me with all the personal data you hold on me. Now, they did this on the assumption that Taylor Wessing provided advices on how the monies were to be distributed. So Taylor Wessing, being a UK law firm, were subject to the Data Protection Act 1998 in the UK, which for all intents and purposes is quite similar to our own act. And so they put in the data subject request and they said, please provide us with all personal data you hold on us. Now, for the time being, we'll take it that Taylor Wessing is a data controller. Park that point, because I just want to address it later. But it was in the first court, it was found that no, you're not entitled to this information. You're kind of seeking it for, reasons relating to law or litigation in the Bahamas, and we don't like the fact that you're doing that, and we don't think you're entitled to the information. So you're not entitled to it. It then went to, that's in the first instance. Then went to the Court of Appeal and completely reversed it and said, no, it's Taylor Wessing is a data controller. The claimant, Ms. Dawson Damer, are data subjects. The data controller holds data, personal data, on the data subjects. Therefore, they are entitled to a copy of all the personal data that's held about them. And in the judgment, they said that a data subject access request is purpose blind. It doesn't matter why you're making the request. It's as simple as, you hold personal data on me, I'm entitled to a copy of it. Simple as that. I could be making it for any reason. I suppose, the point I wanted to park was, now, okay, so that was the decision, and that's 2017. My only kind of point I would make reading it was assumed by the English courts that Taylor Wessing was a data controller. Now, I possibly would have argued there that, which doesn't seem to be, the argument doesn't seem to be made anywhere in the judgment, but I would have argued that Taylor Wessing was actually a data processor on behalf of the Bahamian trusts. And if a data subject access request comes into you as a data processor, you don't have to respond. You ship it on to the data controller and let them deal with it. That was one slight point there. And so in that situation where the data controller is based outside of the UK, it looked like they would have been able not to respond to the data subject request. So we don't know at the moment. There's vagueness over whether a legal firm is a data processor controller. The Information Commissioner in the UK has kind of released guidance indicating that legal law firms are data controllers. All we have from Europe to rely on is a 2010 opinion that kind of looks at accountants and law firms and actually says very vaguely, in some situations it can be a data controller, in some situations it can be a data processor. So if you're a one-man lawyer or accountant and someone comes in off the street and asks you for legal advice, then you're a data controller for that person. But in certain situations, if you have a law firm or accountant senior working on a large project on behalf of another big company, you can be considered posting that on their behalf. That's a bit technical, but just be aware there's a bit of vagueness around there. That's the only thing I'd say about the decision. But you can see that there is, it's a classic example really, sponsored beneficiary using the data protection laws as a way to get information that they want. Now I actually don't know what, well obviously wouldn't be able to find out, but I don't know if she got to see what she was looking for, but as I said, there is a tool there that people can use. Now, closer to home, there is a more recent case, which was last year, and it has a funny name, so I have it written down. It's in my paper anyway, but it is Susquehanna International versus Needham. And now it doesn't deal with trusts, but just wanted to highlight it quickly that it will, the reason it's significant was an Irish court, so it's page 15 there of the paper, but an Irish court basically said, so there was a plaintiff company and a defendant individual. They're involved in litigation, and the company said to the individual, or put in a discovery request to the individual and said, I want all the discovery documents you have. So again, remember, discovery is a document request, not different to data subject access request. And in summary, so the individual said, look, I don't have certain information, it's out of my power of procurement, so I don't have to give you that document, it's under discovery. The company said, but you can actually make a data subject access request to the people that hold that, so you can actually go and get that information, which we want under discovery. And the individual said, look, you can't force me to make a data subject access request. Anyway, court decided, the Irish court, that they actually ordered the individual to go make a data subject access request and said, no, go off, make the access request, any information you get, provide it to the other side on discovery. So that doesn't deal with trust, but just to highlight that how its data access requests are coming into the Irish courts, the significance that they can have, and how the judiciary now can almost utilise it as a tool. So that's Susquehanna International versus Needham. So that's just one to keep in mind. Right. So that's the kind of cases. So right of access is the main one, which everyone talks about. There are other rights the data subject has. You'll be delighted to hear. So I've just listed them there. The right to rectification. So that's to correct inaccurate personal data. The right to erasure is also known as the right to be forgotten. So that in certain circumstances, data subject can ask that you delete or remove information about them. I wouldn't worry too much about that in some, because it's more to do with the classic case under it is the Google Spain case, where just to summarise that one very quickly, was a Spanish individual, Mr. Mario Gonzalez. He decided that, basically what happened was, he was a solicitor based in Spain. Some of you are probably familiar with this case. He went bankrupt 10 years before, his house was sold, he got his life back together, started a solicitor practice, Googled his name, which a lot of people do. And the first result is, Mr. Gonzalez, bankrupt, house sold, etc. He's like, not really great for my solicitor practice if people are Googling me. So he made a case to Google, asked that link be removed from the search site, and ultimately decided that Google had to do that. And now, obviously, the irony of the case was striving to be forgotten. His name now will never be forgotten in data protection. But although I did slightly get it there, but just so it's the point I'm making there is it's kind of more. And I was acting for one of the kind of newspapers, and they get a lot of these right to be forgotten. It's not really. It's more of a right to change a kind of Google link than it is underlying story about someone. So that wouldn't worry too much about that unless you're Google. The right to restriction, then you can have access data blocked in certain or specific examples. Don't worry too much about that. A new big one though is the right to data portability. I'll just flag this where it is you as a data subject can ask a data controller to port or move all your data to another data controller. So that's a brand new right coming in under GDPR. Not sure how much it would affect trustees, but I think more if you're switching a bank account or insurer, you can just ask them to send all the personal data to a new person anyway. New kind of updated right to object. Again, that's you kind of give out if you're using your information for direct marketing and automated decisions. Don't think too much about that. So those are the other rights. I'll just quickly kind of fly through some of the other kind of obligations and responsibilities under GDPR generally. They're good to be aware of if a client comes in and asks, geez, what do I have to do here to be compliant? Or if a trustee might ask it, or it might be good for yourselves just to, if you are data controllers, just be aware. So one of the big ones we're seeing is your processors. You have to have a contract in place between yourself as a data controller and the processor. So I can't just get anyone to do the payroll or back up my cloud. I need to have a contract in place with them if they're processing that on my behalf. The issue there is under Article 28 of the GDPR, there's now a list of things that need to be, about 8 things that need to be in that contract between the data controller and the processor. At the moment, it's just kind of 3 vague things. So we're seeing a lot of companies are going to have to go look at all their processors and go put in new contracts in place with them. So it's creating a lot of work for us as solicitors at the moment, which is great, but not so great for people who have a lot of data processors. So just be aware, review, if you are a data controller or advising a data controller, tell them to review contracts in place with their data processors and make sure that they meet what's called Article 28 requirements under GDPR. Data protection officers is another term that gets thrown around a lot with a bit of confusion. They basically, a data protection officer is kind of a management role, and it's a link between the data subjects, the data controller, and the data protection commissioner. So they're kind of the middleman, which facilitates conversations. They kind of encourage a culture of data protection within an organisation. A couple of key points I just want to make on these, a couple of takeaways. I've listed there the top 3 situations where you have to have data protection officer in place. If you're a public authority, if your core activities are the regular and systematic monitoring of data subjects on a large scale, or processing a large scale of sensitive data. Sorry, and I'm just going to touch on sensitive data there, which is another thing people ask about. Sensitive data is information relating to your health, race, religion, ethnic origin, genetics, membership of a trade union, which is a weird one. So that's all sensitive data. Interestingly enough, financial data is not sensitive data. A lot of people find that very sensitive in their minds, but it doesn't come under the definition. So, but there's just a few higher restrictions under the Act, which I won't go into, but they're just to be aware that when you're dealing with sensitive data, there's a few more hurdles to jump. So just listed there are the 3 times you have to put in a data protection officer, and you might ask, geez, what the hell is regular systematic monitoring of data subjects on a large scale? It's vague enough, and I don't know is the answer to you. European guidance gives a few extreme examples of what is and what isn't, but it'll take a couple of years to work out what the middle ground is. But just be aware there anyway. There's one key point I want to make with a data protection officer, just to take away. A lot of people kind of go, "Jesus, I want to get compliant with GDPR. Johnny in accounts, you're now the data protection officer for the company. Good luck." Wouldn't necessarily recommend that. As soon as you start calling Johnny a data protection officer, all the rights and obligations under the Act apply. If you, funnily enough, if you call him, general data privacy, chief, the Acts don't apply. You can still do the same role. So just be careful if you start calling someone a data protection officer. The reason is there's a few things. They need to have a sufficient expert level of knowledge on data protection. It can be an employee or it can be an outside service person if you want to get that. But they must report directly to the highest management level, and from an employment point of view, they can't be fired for doing their job. So they have some bit of immunity from an employment perspective. So poor Johnny goes up to management and says, "Look, stop sending all our data to Cambridge Analytica or something." And they say, "Johnny, you're fired." No, you can't do that. But if you just call something else, you could. So just be aware of that. security, I don't need to talk too much about this. Keep your personal data secure is the bottom line. There's different ways of doing it. Encrypting data if you can, pseudonymizing data, pseudonymization, which is one of the hardest words in the GDPR to pronounce. What that means is if you've got a list of, and actually this is a kind of key point from a trustee point of view. So let's say we have a list of 100 beneficiaries listed by name. Might be a good idea to say, beneficiary code, so beneficiary 54321, rather than their name. And the reason for that, and then so keep the list of codes, so beneficiary A, B, C, D over here, and the names of list over here. The reason for that is if there is a data breach and someone gets a list of all the identifiers but don't have a list of the names, then it minimizes the data breach that occurs. Now, just because people think, sure, look, I'll start naming everyone and I'll get away now with data protection access request that comes in and I don't have to deal with it. No, pseudonymized data still falls as data because you have the ability to identify that person. They're identified or identifiable. So just bear in mind the difference. Anonymized data, I have no way of possibly identifying that individual. Data protection act doesn't apply. Anonymized data, unfortunately, while reducing the risk from a data breach point of view, which is a good thing, it doesn't get you out of the application of the acts. Just be aware of that one. So I'll kind of fly through. Data breaches and notifications is one of the last things I wanted to talk about. Basically, funnily enough, at the moment, so we've about 2.5 weeks left, there is absolutely no legal obligation if you suffer a data breach to report that data breach to the Data Protection Commissioner or the affected data subjects. No legal obligation whatsoever. There's good guidance that you should do it, but no consequence for doing it. So if you have any data breaches, the next 2 weeks is now the time to do it. But after the 25th of May, things are changing. You have to report it to the Data Protection Commissioner without undue delay or within 72 hours. So a big shift from not at all to, you have 3 days to do it. There's a slight carve out if it's unlikely to result in a risk on freedom of, so let's say you lose a laptop but it's encrypted.